Hey, Taylor Kaspar, answering common questions so that the average person can be reasonably informed about estate planning. I hear a lot of misperceptions or misconceptions about powers of attorney, so I wanted to just set the record straight by answering 3 questions about powers of attorney that everybody should know. The first is this: what is a power of attorney? A power of attorney is a document that allows for somebody to make financial decisions on your behalf if you were unable to make them for yourself. This document is only valid while you're living because it has no effect when you die. So during your lifetime, you can appoint an agent, sometimes called an attorney in fact, who will be able to carry out financial transactions for you, whichever type you choose during your lifetime if you couldn't do it for you, either because you're not able, because you're incapacitated by reason of an accident, illness, or you're out of state or something like that, or you just don't want to. You just want somebody else to be responsible for something for you. You can designate somebody to do that. Most commonly, we see older adults give attorney in fact responsibility to their friends, family, children when they reach a point where maybe they're not getting out of the house as frequently as they used to and things like that. It is important for you to know that powers of attorney in a lot of forms are legally effective from the moment that they're signed. Not all of them, but a lot of them are legally effective at the moment that they're signed. So you need to be really careful about passing the powers of attorney out, or about who you choose to be your attorney in fact under the document, because they could, from the second that you sign it, whether you're incapacitated or not, they can often go ahead and use it right away. The second question I wanted to answer is who needs a power of attorney, or why would you need a power of attorney? And the reason is this. You would need a power of attorney because if you were to become incapacitated and not be able to make financial transactions for yourself, nobody has any legal authority to do that for you. You might think your spouse has legal authority, but they don't. They only have legal authority over any accounts or assets that you are jointly titled on or that you own together. If there is an asset like a separate bank account, like a retirement account, if they own the house and you don't, your spouse does not have the right to make financial transactions or decisions on your behalf if you become incapacitated, if they're not already on that account or otherwise designated. So you need this because if you became incapacitated, nobody has legal authority, and the only way at that point in time to get legal authority would be to go to the courts and petition to have a conservator appointed over you. Conservatorship, free Britney, right, is something that is very restrictive. Once appointed, it's sometimes hard to get out of conservatorships, and conservatorships strip you of your personal liberties. So if a conservator gets appointed to you, but you could reasonably act on your behalf, you're not going to have any right to any longer until the courts determine that the conservatorship is over. And this is very far-reaching. Conservatorships, when that happens, there are notices sent to the state agencies so that we know that you're a person under conservatorship and that you don't have rights to do a lot of things anymore. So it's very, very serious business, and it can all be avoided with a power of attorney. As to who needs one, literally everybody needs a power of attorney document because you just don't know. You don't know. Something could happen to you, and now we're in these dire situations with court involvement, and that's not something that anybody ever wants. Then question number 3 I hear a lot is, well, how do I get a power of attorney? I know it's important. I know I need to do my estate planning, but I haven't gotten around to it. But this power of attorney business seems really eminent. What should I do? And quite frankly, if you live in the state of Minnesota, you can Google statutory short form power of attorney, and the legislature, I think the Attorney General's office and websites like lawhelpmn.com have published self-help usable forms that you can fill out and create a power of attorney for yourself. Now, obviously, doing one statutory short form power of attorney is not a substitute for a complete estate plan, but if you're going to do something, then at least do that and get that in place so that you're not waiting until the time feels right to do a whole estate plan to have a power of attorney, because that is something that you can take into your own hands immediately and get squared away right away, so that if something happens to you, you're not going to be subject to the courts. Taylor Kaspar here, owner, managing attorney of Legacy Estate Planning in Burnsville. I hope you found this information useful and that you can take something away from the video today about powers of attorney.